Committee on Oversight and Government Reform will come to order, and pursuant to Committee Rule 5B and House Rule 11-2H4, the Chair announces that he may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. Without objection, the Chair is authorized to declare a recess at any time. Members are advised that we will have a vote on the floor, and it is the intention of the Chair to recess while we do those votes and then come back and continue with the business. Our first item for consideration is House Resolution 5233, the clarifying congressional intent in providing for D.C. Home Rule Act of 2016. Clerk will designate the bill.
H.R. 5233 to repeal the Local Budget Autonomy Amendment Act of 2012 to amend the District of Columbia Home Rule Act to clarify the respective roles of the district government and Congress in the local budget process of the district government and for other purposes.
Thank you. I ask unanimous consent that the bill be considered as read and open for amendment at any point. Without objection, so ordered. Now recognize the sponsor of the bill, the gentleman from North Carolina, Mr. Meadows, who's also the chairman of our subcommittee on operations within the Oversight and Government Reform Committee. But we'll now recognize him for 5 minutes to explain the legislation.
Thank you, Mr. Chairman. I would first like to state that I continue to believe that the Local Budget Autonomy Act is null and void, and I agree with the former D.C. Attorney General Irvin Nathan that should the issue come before a court again, Judge Sullivan's opinion declaring the Local Budget Autonomy Act unlawful will be vindicated. Unfortunately, Congress cannot afford to wait for the judicial branch to sort this issue out. Congress has the authority to settle this issue once and for all through the exercise of its legislative powers, and given the potential real-world ramifications that may result from the implementation of the Local Budget Autonomy Act, which experts have testified may range from fiscal chaos for the district to administrative and possibly criminal penalties for district government employees, we must act now. Last week I had the opportunity to chair a hearing on the Home Rule Act of 1973 and to answer a crucial question. What powers did Congress intend to delegate to the District of Columbia when it passed the Home Rule Act? At that hearing, we heard from individuals on both sides of this debate, supporters and opponents of the Local Budget Autonomy Act's legality. I think most will agree that it's hard to draw any conclusion from that hearing other than the fact that Congress never intended to delegate to the district budget autonomy for the congressional appropriations process. In fact, Mr. Jacques Dupuis, who was intimately involved in drafting the Home Rule Act as counsel to the House committee that approved the bill, testified that the budget process was, in his own words, quote, off limits to local government, close quote. Moreover, the extensive congressional record that exists from the debate and passage of the Home Rule Act supports the idea that the budget process was expressly reserved for Congress and not within the limits of the purview of the district. As Mr. Nathan asserted, to believe that Congress did not wish to reserve the appropriations power for itself in the Home Rule Act, quote, violates common sense, close quote. At the hearing, even the chairman of the Council of the District of Columbia was forced to acknowledge that it was clear that the majority of the members of Congress who passed the Home Rule Act intended to reserve the complete appropriations process for Congress. To suggest that any city council's action, whether in the district or any other city in the country, can unilaterally overturn the intent of Congress would set a bad precedent. Regardless of the precedent, however, such action by a local government is a blatant violation of the Supremacy Clause and therefore unconstitutional. Again, I would wish to reiterate that if it were prudent to wait for the courts, I believe the courts would ultimately find that the Local Budget Autonomy Act unlawful. However, such a delay is not prudent. If the district moves forward with spending funds absent congressional appropriations under the Local Budget Autonomy Act, they will be inviting potential negative consequences by violating the Anti-Deficiency Act. The penalties that result from a violation impact not only the mayor and city council, but employees of the district government And that is why I put forth this legislation. H.R. 5233 will strengthen the clear congressional intent of the Home Rule drafters in 1973, reserving for Congress the appropriations powers as it relates to the district budget. This bill will also remove the risk that different district government employees created by the Local Budget Autonomy Act, and I urge my colleagues to support this bill and help protect district government employees and preserve the Congress's plenary legislative authority in the intent provided in the Home Rule. With that, I'll yield back, Mr. Chairman.
I thank the gentleman. Now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Chairman, I strongly oppose this bill, which would repeal the district's Local Budget Autonomy Act and prohibit D.C. from passing such laws in the future. I want to express my disappointment that some members have threatened jail for D.C. employees who implement the Autonomy Act. The threat is backward. In fact, district officials may face jail for not implementing the Autonomy Act. The only court ruling in effect on this law upheld it and ordered all district employees to implement it. The committee has also taken a regrettable turn in its approach to D.C. Home Rule. The last 4 chairmen, including Republicans Tom Davis and Darrell Issa, tried to give the district more Home Rule, including budget autonomy, not less. In this Congress, the committee has passed legislation to overturn a district law that prohibits employers from discriminating against employees for their reproductive health decisions. The majority also launched an investigation of the district's marijuana legalization initiative and threatened the mayor with jail for implementing it. We hear a lot of rhetoric from the majority in support of devolving authority to local governments. Yet this bill tramples on a local government and the will of the local citizens expressed in a referendum. This bill is not only unprincipled, it is bad policy. Even as this bill was being drafted, the majority's own hearing witnesses were calling for D.C. budget autonomy. Mr. Chairman, if the committee insists on marking up this bill, I hope at the next markup we consider a bill to give D.C. budget autonomy. And with that, I yield the rest of my time to the distinguished lady from the District of Columbia, Ms. Norton.
I thank the ranking member for yielding and particularly for his remarks. Mr. Chairman, this is the most significant abuse of congressional authority since the passage of the Home Rule Act in 1973. Anyone who wants to opine on what the Home Rule Act meant at that time, and we've heard some indication, needs to know that the Senate of the United States actually gave the District of Columbia budget autonomy. So what emerged was a compromise, and one would have to look very closely at legislative interpretation and to get into that back and forth. Let's put to rest right again this newest threat under the Anti-Deficiency Act. The District of Columbia has been mandated by court order to proceed by the Superior Court of the District of Columbia, and it is important to note that the Federal Court on Appeal yielded to, sent this matter back to our local court. That court didn't simply stop saying what it believed it, by court order, mandated the District of Columbia to proceed to implement the Budget Autonomy Act of 2013. There are 3 reasons why we shouldn't be holding this hearing. First, I would think everyone would see it shameful to hold such a profoundly undemocratic hearing markup as to overturn a jurisdiction's local budget. Second, it would harm the finances and operations of the District of Columbia. And third, it is completely unnecessary because Congress loses none of its authority by proceeding, by allowing the District of Columbia to proceed. This is, in effect, a show hearing. We've all heard of a show trial. This is the functional equivalent, because even before last Thursday's hearing, the committee had indicated it would mark up the bill. That's before they'd heard a word as to whether it was legal, constitutional, or the rest. While the committee in the House almost always passes whatever this committee says, the Senate doesn't have the votes to pass this bill, and everybody knows it on this side. If it did, the President would oppose it. He has had budget autonomy in his own budget submissions for the last several years, and almost certainly he would have to veto it. Instead, as the committee has already made clear, it's going to try to attach the budget autonomy repeal to an appropriation bill.
The gentleman's time has expired. We do have a vote on the floor, so
Now, just a moment, that was the gentleman's time. Could I therefore pause while you go to vote and then get my own 5
yes,
minutes?
then the gentlewoman will be recognized for a full 5 minutes, and we can take it up from there. But the
Thank you,
gentleman,
Mr. Chairman.
this was all on Mr. Cummings' time.
Can she conduct the hearing while we're going?
I'll go ahead and put this in my pocket while we go. We'll be right back. We will stand in recess. We have 4 votes on the floor. We will be here no sooner than 2:40, and even that is optimistic. The committee stands in recess until at least 2:40 or when we
Very
conclude
much. That was
votes.
brilliant.
Good try, though.